Hold on to your hats, folks, because we're diving into the wacky world of U.S. immigration law, specifically the Immigration and Nationality Act of 1952. This behemoth of a document is basically the rulebook for who gets to step foot in the land of the free, and who's stuck waving from the other side of the Statue of Liberty. Now, you might think a law from 1952 would be as outdated as a rotary phone, but you'd be wrong. This act, despite its age, still forms the bedrock of U.S. immigration policy. Sure, it's been tweaked and amended over the years like a vintage car with a new paint job. But the core engine, the fundamental principles remain largely the same. This act covers everything from visa categories to deportation grounds. It's a complex web of rules and regulations that can make your head spin faster than a teacup ride at Disneyland. But don't worry, we're not going to dissect the entire thing. We're going to focus on a couple of particularly juicy sections, 237A, 4, C, and 212, F. These sections, my friends, are like the hidden clauses in a contract. They don't get much attention, but they pack a serious punch. They give the president and his administration a surprising amount of power to control who gets to stay in the U.S. and who gets shown the door. Let's start with section 237A, 4, C, shall we? This little gem allows the Secretary of State to revoke visas and green cards from people considered detrimental to the interests of the United States. Sounds vague, right? That's because it is. It's like trying to nail jelly to a wall, this provision. What exactly constitutes a threat to U.S. interests? Is it criticizing the government, wearing socks with sandals, bringing pineapple on pizza? The law doesn't say. This ambiguity gives the government a lot of leeway in how it's applied. Now, you might be thinking, surely this provision is only used in extreme cases, right? You'd be mostly right. Historically, it's been used sparingly, like a bottle of fine scotch saved for a special occasion. One notable instance was the case of Mario Ruiz Massieu, a former Mexican official accused of corruption. In 1995, the Clinton administration used Section 237A-4-C to deport Massieu, arguing that his presence in the U.S. was causing diplomatic tension with Mexico. It was a controversial move, but it showed that this obscure provision had teeth. Now let's hop over to Section 212, EF. This bad boy is even more potent than 237A-4-C. It essentially gives the president the power to ban entire groups of people from entering the U.S., if their entry is deemed detrimental to the interests of the United States. See that phrase again? Detrimental to the interests of the United States. It's like a magical incantation that gives the president free rein to do whatever he wants in the name of national security. And boy, oh boy, have presidents used this power. Remember Trump's travel ban? The one that barred citizens from several Muslim-majority countries from entering the U.S.? Yeah, that was Section 212F in action. Trump argued that this ban was necessary to protect the U.S. from terrorism. Critics, however, saw it as blatant religious discrimination. They argued that the ban was based on fear and prejudice, not actual evidence. The legal battle over the travel ban went all the way to the Supreme Court, which ultimately upheld a modified version of it. But it's not all doom and gloom, folks. The 1952 Act also contains a provision that allows for a glimmer of hope, humanitarian parole. This provision allows the government to temporarily admit individuals who wouldn't otherwise qualify for entry into the United States, usually for urgent humanitarian reasons or significant public benefit. Think of it like a get-out-of-jail-free card for people facing dire situations. It's been used to grant entry to refugees fleeing war-torn countries, individuals seeking medical treatment, and even witnesses in criminal trials. The Biden administration has utilized humanitarian parole to offer a lifeline to people fleeing violence and instability in countries like Afghanistan, Ukraine, and several Latin American nations. It's a beacon of hope in an otherwise unforgiving system, a testament to the idea that America can be a place of refuge for those in need. However, the future of humanitarian parole remains uncertain. Its use has been challenged in court, with some arguing that the Biden administration is overstepping its authority. The legal battle over this vital lifeline is ongoing, leaving countless lives hanging in the balance.
Hey, we all want to scale our business. Hey, I have the answer for you today to help you do that. If you're looking to scale from 5, 6, even 7 figures and beyond, book called Be Good, Be Brief, Be Gone. I'm going to give it to you for free. All you have to do is type in growfast.cash. I say again, growfast.cash, and you can download the book for absolutely free. I hope the book helps you this year. Take your business to the next level. Again, go grab the book, growfast.cash. I say again, growfast.cash. I wish you the best and grow, scale, and win.
There it is. Magnum. Holy moly.
Yeah, baby! That's what I've been waiting for!
Dear God, it's beautiful.